This We the People News, not attorney, not giving legal advice. Educational purposes only. Okay? Never look straight forward, always look around you, be able to protect yourself by any means necessary. As usual, y'all, use that Second Amendment, arm yourself with knowledge. But you gotta think outside the box as well. Alright? This is more along the lines of a part of state citizens and not the U.S. citizens. Okay? Um, Back in the day, before the 14th Amendment, we was all state citizens, and in order to join this country, you had to be a particular state, and you had to do the paperwork to be a state citizen. Okay, uh, because they had separate powers at once upon a time. All right, um, let's check out what he has to say about this arm length.
Preamble posterity. The respondent in error has ancestors who owned land in Pennsylvania during the War of Independence and also volunteered to serve on the militia. Therefore, the respondent in error is posterity is found in the preamble. He is entitled to right of blood, and no civil law can destroy right of blood because all the laws of Congress and all the laws of New Jersey are civil laws. And this court, as well as all the plaintiffs, are operating under power which is derived from the respondent in error as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. Therefore, it's impossible for the respondent in error to give any of these plaintiffs or their bar member handlers or this court any authority over the respondent in error, and John Marshall, Chief Judge of the Legislative Inferior Court of the United States, agreed and said it's impossible for the respondent in error as one of we the people to confer a sovereignty which will extend over him. And that's McCullough versus Maryland again. And the respondent in error is exempt from these plaintiffs because and from all of the claims of their bar members, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And the respondent in error requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary notwithstanding, Article 6, Clause 2. And we the people failed to be 14th Amendment U.S. citizens because the 14th Amendment U.S. citizen failed to exist when the Constitution was written. All of which is evidenced in the affidavit of citizenship, a true copy of which is attached here too, and the appendix at pages 1 through 24. And I'm not sure if he's got an affidavit of citizenship. I need to talk to him about that. There's nothing this court can do to affect the respondent in error. Let's see what page are we at. Okay. State citizens are the only ones living under free government. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. The sovereignty of a state does not reside in the persons who fill the different departments of its government, but in the people, and from whom the government emanated, and they may change it at their discretion. Sovereignty then in this country abides with the constituency and not with the agent. This remark is true both in reference to the federal and state government. The plaintiffs in this case have repeatedly called the respondent in error a sovereign citizen, and it is true as evidenced by the resolution of Congress, because we have a Republican form of government. There we are all sovereign citizens, as evidenced in House Joint Resolution 183, dated May 3rd, 1940, at 54 Stat 178, where it says in the preamble, whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic.
Okay, and it did change a little bit, like a couple of years later, but they just kind of used the different words to kind of dilute the sovereign citizen thing, but it still stands. Today, we actually call it September 17th, Constitutional Day, but it is tied into the 1940 sovereign citizen with Harry Truman. I believe it was Harry Truman. Okay? It didn't abolish it. They just kind of changed it every so often, the words. But, now today it's called September 17th, Constitutional Day.
The plaintiffs and their bar members are required to know that the Supreme Court of the United States has ruled that everyone and everything not privileged is sovereign, but the plaintiffs have called the respondent in error a sovereign citizen like it's some sort of a bad thing, which is an attack against the republic itself. And the plaintiffs have repeatedly issued letters of bark and reprisal and have taken reprisals against the respondent in error in support of their targetedjustice.com website to show a long train of abuses and usurpations pursuing invariably the same object. Events are designed to reduce them under absolute despotism, which is...
Now, if I was him, okay, I would probably use what the founding fathers said, right? Usurpation, and then cause domestic abuse, and what was the other one? Trespassing, right? And because they're all trespassing upon our we the people's rights, okay, and our natural men and women rights, okay, especially when there's no harm, loss, and damages to another, right? They have jurisdiction in that matter. There must be a victim, and that victim must sign an affidavit under penalty of perjury, except the ones that didn't survive it, right? You had to have the investigation and go through that process, right? But short of any other way, you have a right to face your accuser. Okay, let's go.
An attack against the republic itself, which is why the respondent in error is so sad and disappointed, because it looks like the judge is giving aid and comfort to the enemy in a time of war, or is mistaken.
Now, furthermore, the administrative came from your Texas, okay, for y'all as well, but since I'm in Texas, it's administrative is coming from your representative, the legislature branch. All right, it's their rules under Texas codes and all that kind of stuff. So even crimes, people going to prison for drugs and all that, it's under administrative under the Legislature Act, not the judicial. You don't never see a judicial judge. Well, they're the ones that's supposed to be convicting you, not the administrative. Right? A real judge must issue a warrant for your imprisonment. But, it's so hard to convince people some of these things that they're doing wrong. Come on, y'all. Think outside the box.
The original Constitution of the United States, dated September 17th, 1787, has never been declared void and is the oldest written Constitution still in effect today. Now, some of this stuff a lot of this stuff here is stuff that we've talked about in other documents, and this is stuff we're adding into this one. I don't know. Do you guys want to go through all of this? We've talked about it before, or we could skip down to. So we're going through this stuff about the fact that and the Northwest Ordinance, and actually we cover that up top too. Maybe we should thin it down a little bit. Legislative statutory law, maritime code. And it's talking about common law. There we go. We'll get to the jurisdictional issue. Respondent in error has been challenging jurisdiction at every step of this proceeding. Actually, I've been tweaking it here.
The number one way you can find out whether it's a good magistrate or a good judge, when you challenge jurisdiction and they explain how there is jurisdiction. Okay? That's the number way. If they do not explain it and they just say they do have it, then they are violating their own rules of conduct. The Supreme Court cases tells them that they must clarify how they have jurisdiction. Okay? But you get these attorneys out there calling people sovereign citizens and all this kind of stuff because they challenge jurisdiction. All right? Just saying. We need to know how they have it. And usually it's by the plaintiff. They're the ones bringing the claim. The judge is not even supposed to say, I have jurisdiction in the first place. It's the plaintiff that brings the jurisdiction in. And the judge accepts the jurisdiction. All right? All right.
Respondent there has been challenging just every step of this proceeding, and this has had the effect of negating the presumption that the court had jurisdiction in this matter. Jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. So there's court cases to say that a court is not capable of deciding its own jurisdiction. So really what you have to do is get it into the Court of Appeals. Anyways,
but the question still remains, if it's a good magistrate or a good so-called judge, they know these things. They're just violating your rights. Just right from the very beginning, if you challenge jurisdiction and you go in there, I forgot the other word right now, but if they don't clarify it, they're violating your due process rights. That part right there, I don't know how hard that is for some people to comprehend. Okay? It's a violation of due process. Okay?
because the court can't decide its own jurisdiction.
No. It's got to come from the plaintiff.
Technically, they weren't supposed to move forward, and the prosecuting attorney was supposed to take it to a higher court. Once you challenge jurisdiction, that judge is supposed to be unbiased and is supposed to kick it back to the prosecuting attorney and discharge the matter.
I agree, but they're not. They want to sell you into slavery is what they do.
Then he's practicing law from the bench in his private capacity.
I agree. But you got to win your case before you can sue them. So, anyways.
See how they're doing this to the people? And then if you have an attorney, you can't do it because the attorneys won't do it. Now, you may eventually win your case, but you may not because they are working under the same corruption. All right? And then you got a challenge. You don't want the administrative. You want judicial. Okay? Especially in criminal. All right? If I'm going to be convicted, I want a real judge and real trial by jury. Not a jury trial, but a real trial by jury to convict me. And a real trial by jury, it must be unanimous. It was supposed to be hard to convict people and send them to prison. Why? To ensure that innocent people don't go be sitting in prison like today, y'all. 30 years later, getting out of prison. Because they had a, 6-1 or, this, that, here, and there. When it's supposed to be unanimous. Just saying. Jason We the People News. Bye, y'all.